Before this hearing even gets fully underway, pay close attention, because this case is about to spiral from a routine court appearance into a courtroom showdown that nobody saw coming. At the center of it all is Robert Williamson, a defendant who says missed mail, hearing problems, and confusion are the reasons he failed to appear in court. On the other side, you've got a judge who clearly believes personal responsibility starts the moment someone knows they have pending charges. What makes this hearing so fascinating is that the entire tone of the case shifts almost minute by minute. At first, it sounds like a simple discussion about missed court notices, but then questions start piling up. Did the defendant really not receive the notices? Were there legitimate communication issues? Or is the court looking at a pattern of avoiding responsibility? And here's where things get even more dramatic. What starts as a conversation about missed appearances quickly turns into arguments about criminal history, courtroom behavior, bond amounts, respect for the court, and whether the defendant can be trusted to follow future orders. Watch closely, because every interruption, every reaction, and every decision made in this hearing ends up affecting what happens next. By the end, a bond amount skyrockets, tempers flare, and both sides dig their heels in. The big question is, are we watching a misunderstanding spiral out of control, or are we seeing exactly why judges take courtroom conduct so seriously?
Your name, sir?
Oh, Robert Williamson.
Officer, sergeant, your name or corporal? I can't tell.
Sergeant Mitchell.
James Schlock 30720.
These guys don't get it, do they? Why didn't you show up? Why didn't he show up?
And my mail goes to I'm in an apartment complex, and I don't get no. Sometimes I don't get no mail at all.
You remember getting stopped, right?
I'm sorry, what? I can't hear. I'm half deaf. I'm sorry. I'm half deaf.
All right, let me put it to you this way. You got stopped. I don't want you to acknowledge that you did, but at some point it's going to be pretty clear to me that you did get stopped. If you had mail issues, you should have called the courthouse. You should have called the police department. Now you got yourself in a real predicament. What, is there a problem with something I just said? I don't want you to cop an attitude with me. If you do, we're going to have a bigger problem.
No, I'm half deaf. I can barely hear you. I'm half deaf. I can't hear you. That's the problem.
Okay. All right. Can you hear me any better now?
Yeah, that's all the problem was. I couldn't hear you before. Now what's going on?
Does he stand mute and waive formal reading?
Yes, Your Honor.
I'm entering a not guilty plea. I got an operating with the presence of drugs, and I got a resist, hinder, and obstruct an officer charge. So your lawyer is telling me you stand mute and waive formal reading. Has he been printed on this, Sergeant?
Yes, he has.
I want to know why he hasn't shown up.
I apologize.
Why did you not show up?
I didn't get notice.
Well, you knew you got stopped. You should have called the court. We sent it to 311 Adams. Is that your address?
That's my address, but sometimes things get dropped. Sometimes things get dropped. You know what I mean?
We sent 2 letters there. If they came back, we would have put them in the file.
Oh,
you were supposed to be here on April 30, and then you were supposed to be here on May the 14th, and you didn't show up either time, and I don't have any return envelope or any envelope stamped.
This is one of those moments where courtroom procedure collides with public perception. The defendant is focused on explaining why he missed court, but the judge is focused on something entirely different, whether there is a reliable explanation for 2 separate failures to appear. Legally speaking, judges often view missed court dates as a major warning sign because attendance is one of the most basic obligations in any criminal case. At the same time, notice how the discussion starts drifting toward prior criminal history. Even though older convictions may not directly determine guilt on current charges, they can still appear in background discussions during bond and risk assessments. The real question here is whether the court is evaluating current behavior or allowing past conduct to influence present decisions. What do you think? Should decades-old history still matter when a judge is deciding how much trust to place in someone today?
that was
Well, I went to
sent
the
back to
hospital
the
for 15
courthouse, or it would be in the file. Where does he work?
He's on disability, but he has no prior cases. He did tell me about his mail issues. And,
He's got prior cases. I mean, he's got a heck of a history here. Home invasion, 98. Impaired,
You
99.
can't hold that against me. You can't hold that against me. You can't hold none of that against me because that was over 12 years ago. You can't hold none of that against me. 10 years or older, they don't hold it against you.
sure, it is your history. I will tell the court that it is pretty old and, you make the right conclusions based on that. Okay?
I'm
we're talking
just- You can almost
I'm getting mixed signals. I'm getting mixed signals. Yeah, you're gonna talk about my history. Just 10 years or older.
Really? Thank you.
I could just go to trial with it and then show you that they kept me in the police station for 2 days before they took me to the hospital.
Sir,
Even prove that I had
we're not
drugs in my
going to talk
system.
about the substance, especially.
They kept me for 15 days in the hospital.
court.
And then,
You'll have an
now you ain't
attorney
doing
next
it.
time who
Just let
will
me go.
able
I'll come to
discuss
court and I'll
those-
take care of it. I promise.
Sir,
I just
you'll
didn't
have
get
an
notice.
attorney next time who will discuss those issues with you. Today, we're just concentrating on bond.
I was reading your history as I was reading it
Yeah,
to
well,
myself.
you can't read my history because it's over 10 years
Yeah.
old.
Don't interrupt.
Are you
the
dealing with
judge.
me or him or them?
Horrible hip.
He's
You got
switching
a-
me around. Why don't you stop switching me the fuck around, bro?
How about you stop talking and listen?
And here is the turning point of the entire hearing. The judge has just raised bond to $40,000 at 10%. And the reasoning isn't based on whether the defendant is guilty or innocent of the underlying charges. Instead, it's tied to what the court perceives as a potential flight risk and a pattern of non-compliance. This is an important distinction many viewers miss. Bond hearings are not trials. The court isn't deciding guilt at this stage. It's deciding whether someone is likely to return to court and follow court orders. But notice how quickly emotions begin taking over the conversation. The defendant feels blindsided by the increase, while the judge views the escalating behavior as confirmation of his concerns. When frustration starts replacing strategy, outcomes can change fast. Do you think this bond increase was justified, or did the situation escalate further than it needed to?
I'm going
I
to
can't,
set you
I'm deaf.
bond now. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. If you're going to be so defiant, that tells me you're a flight risk. 40,000, 10%. No alcohol, no marijuana, no illegal controlled substances. None.
My bond is 40,000.
10%. It could be 40,000
Can't be because
if you use
it
the
can't be
F-bomb
because
again.
I have 2 misdemeanor charges, bud.
Sit back.
We're going to trial then, bro.
Sit back.
It came in from $750 to 40,000 over nothing. I'm fucking this whole state up then, man.
You got
We're going
about
all the way to
15
Supreme Court. We're going to court on this.
You got about
You can't
15
sit there and take me from a $250 bond to 40,000 for nothing.
You just used the F-bomb. You're disrespectful. I think you're a
No,
flight
I'm not.
risk. You got 15
I'm
criminal
not. How am I a
convictions
flight
on
risk?
you.
I
Listen,
live right here. I don't even have a car.
Stop interrupting.
I can't
40,000.
hear for one.
well, you seem to be able to hear when you started to defend yourself. 40,000, 10%. You cannot leave the state, cannot violate a law.
So you keep me in
must
jail the whole
appear-
time?
Listen, if you give me one more bit of guff, I'm setting this case for next October, and I'm setting a bond of 100,000 cash. You want to keep going on, tough guy? You want
I'm
to
not
keep
being
going
tough. I
on,
can't-
tough guy? Feel free.
I want a
Yeah.
PR bond. I want to go home. I want to go home. I want a PR bond.
40,000.
Please,
No,
please.
no, no. You're
But then I'm
disrespectful.
suing you then.
What we're witnessing now is a complete collapse in communication. The defendant is moving from anger to desperation, asking for another chance, apologizing, and even trying to reset the conversation. Meanwhile, the judge appears convinced that the earlier behavior revealed the defendant's true attitude toward the court process. One thing worth noting is that courtroom credibility can be incredibly fragile. Whether fair or not, judges often form impressions based on demeanor, interruptions, and how someone responds under pressure. Once a judge believes a defendant is being argumentative or disrespectful, Reversing that impression can be extremely difficult. The irony here is that both sides are now talking about different issues entirely. One side wants to discuss fairness and circumstances, while the other is focused on authority and compliance. That's usually when hearings become the most volatile.
Good, sue me. Okay? Come on, bring it on. Can't wait.
I'm never gonna get out, man.
40,000.
Come on, man, don't do me like this.
Will the court
What?
give us this possible?
Yeah, I'll do that, but he's not gonna yell at me and talk. Use
I didn't
the
mean to yell at you.
F-bombs.
I can't. I'm deaf. I didn't mean to yell at you.
You use the
I
F-bombs.
apologize. Can we start over?
No,
Please?
no,
Can we start over?
no,
Please?
no, no.
Please, can we start? I can't hear you, that's why I'm yelling. I'm not
You
a tough
use-
guy. I just.
You used the F-bomb with me.
No, I didn't.
Oh, you did?
I never cussed you. I would not disrespect you. I just. I can't. I
Listen.
wouldn't disrespect you like that. I apologize.
Listen,
Please, my mom's dying right now. Will you please let me go home?
I'm convinced you can hear a lot better than you think, or at least letting on, because all of a sudden you were able to comprehend. Now, I'm not going to argue with you. I'm telling you, it's June 11th at 9:30. 40,000, 10%. One more word, and I'm setting it for June 25th.
This is a different charge. Why are you doing two different charges? That's not me.
Sir,
What you read
it's
right now
gonna
is
be
that's
next
not me.
week.
June 11th. That's not.
We're gonna get you in front
It's
of
two
the
different
court,
people.
and the court could review your bond at that time. And you can discuss the issues with your attorney at that time.
Oh, you're my attorney. Well, so I don't know how it's
Say
going
that.
on
I
here.
said,
I get 5 different things going on right now. That's all.
June 11th is your next court
Thank you,
date,
sir.
is what they're saying.
One thing I've decided, Mr. Williamson, I'm not listening to tough guys. You got it? You want to play tough guy? Get into
I'm not playing
WWF
tough
or
guy.
something. I don't know what to tell you. June 11th.
I'm sorry. I apologize.
No, it's not good enough.
I'm half deaf. I didn't know all the screens were up.
I could set it. I could just find you in contempt of court.
I didn't know
and
that
lock you
all
up
the
for 30
screens were up.
days. One more word. I'm going to do that. I'm telling you.
I have mental
June 11th is a
disabilities. Just
couple
hold
of
on.
days.
I have mental disabilities.
Cut
Can
'em
you give me
off.
1 second?
Cut him off, Lisa, please. Wilkins Alexander III. 267-665-269, A and B.
Good morning again, Judge. It's, John Graziani, bringing on behalf of themselves.
Is she in here?
What began as a discussion about missed notices and court appearances ultimately turned into a lesson about how quickly courtroom dynamics can influence outcomes. Throughout this hearing, the judge repeatedly emphasized responsibility, compliance, and respect for court orders. The defendant, meanwhile, argued that hearing difficulties, mail delivery issues, and misunderstandings played significant roles in the situation. The most significant ruling was the bond determination. The court concluded that the defendant's conduct, missed appearances, and interactions during the hearing justified maintaining strict release conditions and a substantially higher bond amount than the defendant expected. Whether viewers agree with that decision or not, this case highlights a reality of the legal system. How a person presents themselves in court can sometimes have a major impact on immediate procedural decisions. It also raises larger questions about communication barriers, disability accommodations, judicial discretion, and where courts should draw the line between frustration and noncompliance. Was this a defendant who wasn't being heard, or a defendant who wasn't listening? Let us know your thoughts in the comments below. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.